Welcome to this presentation, which gives an overview of the proposed off-payroll working reforms that will apply to the private and the public sector from 6th of April 2020. This recording is made in July 2019 and is based on the draft finance bill published on the 11th of July 2019. Amendments may be made prior to the legislation being enacted, so please refer to the IR35 pages of the RSM website at www.rsmuk.com/IR35 for the latest updates and insights. I'm David Williams-Richardson, and I'm joined by my colleague Lee Knight for this presentation. In terms of background, the so-called IR35 legislation was introduced in 2000 with the intention of ensuring that workers who decide to operate via structures such as personal service companies should broadly pay the same amount of tax and NIC as an employee. A significant flaw with the original rules has been the fact that the onus has been on the personal service company to self-assess whether or not the rules apply. HMRC estimate that there is up to 90% non-compliance, which will result in lost revenue of $1.3 billion a year by 2023 in the absence of any change. In order to start addressing this non-compliance, the IR35 rules for public sector end users of services provided by personal service companies was changed from 6th of April 2017 to put the responsibility for deciding whether or not the IR35 rules apply onto the end user of the services. The reform also made the fee payer responsible for accounting for income tax and NIC, including employer NIC, where the rules apply. The government believes this reform has significantly increased compliance and now intends to extend the public sector reform to engagements with medium and large organisations in the private sector for payments from 6th of April 2020. The legislation from 6th of April 2020 also includes some changes to the existing public sector rules that public sector entities will need to be aware of. It's important to note that these rules apply to the provision of services via intermediaries such as personal service companies. The changes we are discussing today do not impact existing obligations to determine employment status where you're engaging a self-employed individual. So what is changing from 6th of April 2020? To summarise, the new off-payroll working rules will apply where payments are made on or after 6th of April 2020, where a worker is personally providing services via an intermediary, such as a personal service company, and the end user of the services is either a public sector entity or a medium or large private sector business. The rules will not apply where the end user of the services is a small private sector business, and Lee is going to talk through the qualifying criteria for small businesses shortly. Under the new rules, the company that is using the worker services will need to assess each engagement and decide whether or not the worker would be deemed to be an employee if they weren't operating via an intermediary such as a personal service company. The end user must then provide a status determination statement setting out whether or not the rules apply and the reasons for reaching that decision. The end user will also need to put in place an appropriate status disagreement process, and we're going to discuss this in more detail in a moment. It's important to note that the business using the worker services will need to provide the status determination statement, both in situations where they contract directly with the personal service company and also where they source the personal service company worker via a third party, such as a recruitment agency. The determination statement will need to be provided to both the worker and the agency where applicable. Where the end user of the services concludes that the rules do apply, then the fee payer, ultimately paying the personal service company, will need to account for tax and NIC, including employers' NIC at 13.8% via PAYE, as well as apprenticeship levy where applicable. The fee payer paying the personal service company may be the end client for direct engagements, or it could be an agency or another third party, depending on the particular arrangements.
So as David mentioned, the proposed carve-out for small end users in the private sector has been maintained, and this will be based on the meaning of small given by the Companies Act 2006. Therefore, for the private sector, and subject to some complexities which we will highlight on the next slide, these off-payroll working rules will not apply to end users who are small. Now, an independent limited company that is not otherwise barred from being small, which we will cover on the next slide, will be small where it meets at least two of the following three tests: a turnover of £10.2 million or less, £5.1 million or less on its balance sheet, and 50 employees or less, measured by the average number of employees in the year. For a small end user in the private sector, the old IR35 rules will therefore apply, meaning that the worker's PSC, not the small end user, will be responsible for assessing and applying IR35. Now, these tests for being small are considered for the financial year that is relevant to the tax year. Broadly, the financial year that is relevant to the tax year is the one that ends before the start of the tax year. As an example, if a company's year end is the 31st of December 2019, then this will be the financial year that is relevant to the 2020-21 tax year, as the 2020-21 tax year is the next tax year beginning after the 31st of December 2019. For those companies that are close to these thresholds, this will need to be carefully considered on an annual basis. Where a company meets or ceases to meet these conditions for being small on its balance sheet date, generally the end of the financial year, that affects its qualification for being small, but only if it occurs in 2 consecutive financial years. This means that a company which is a small company in one financial year, but then ceases to meet the qualifying criteria to be a small company, will only be regarded as medium or large-sized if it does not meet the qualifying criteria for 2 consecutive financial years. Equally, a company not previously qualifying as small, which subsequently meets the small qualifying criteria, must meet those qualifying criteria for 2 consecutive financial years before it is reclassified as small. There are, however, a number of complexities around this small company exception to consider. Firstly, there are rules in the draft legislation which mean that a company regarded as small for its first financial year unless it is a subsidiary of a medium or large parent. Secondly, some companies are always barred from being small regardless of their turnover, balance sheet total, and the number of employees. Public companies, certain companies in the financial services industry, members of groups containing traded companies, entities with securities traded on a regulated market in the EEA, and certain financial services entities cannot be regarded as small under the Companies Act, and so are not small companies for the purpose of these off-payroll working rules. Thirdly, the conditions for being small differ depending on whether the end user is a joint venture, a subsidiary of a larger business, or an unincorporated entity. As an example, take a subsidiary of a parent company which is not otherwise barred from being small. Where an end user is a subsidiary of a parent company, the position for the subsidiary mirrors the position of the parent company. If the parent company's aggregated accounts, which are relevant to the tax year, are not considered small, applying a slightly different set of thresholds, then the subsidiary entity would also not be considered small for the purposes of the off-payroll working rules.
So in summary, public and medium and large private sector end users of services provided by intermediaries such as personal service companies will have the following obligations from 6th of April 2020. Firstly, all impacted workers providing their services via an intermediary such as a personal service company will need to be identified, including those who are sourced by a recruitment agency. The end user of the services will then need to make a status determination using reasonable care and then provide a status determination statement, including the reasons for reaching that determination, to both the worker and any other party involved, such as a recruitment agency. The end user will also need to set up an appropriate status disagreement process. In the case of direct engagements, where the initial determination is that the rules do not apply, processes will need to be put in place to review the arrangements periodically in case of any changes. Where there is a direct engagement that is within the rules, then the end user, as the fee payer, will need to ensure that it obtains appropriate details in relation to the worker and then put suitable processes in place to enable PAY and NIC to be operated. It's important to emphasise that the IR35 legislation only applies where an individual, the worker, personally performs or is under an obligation to personally perform services for a business. On this basis, the rules clearly do not apply to contracts for the provision of goods rather than personal services. The position where full services are contracted out to a third party can be complex, and it will be necessary to review the contractual arrangements carefully. Where the contract does in fact include provisions for the direct supply of labour, then the company outsourcing the arrangements will still need to apply the rules and make the status determination as the end user. Where, however, a company has genuinely fully outsourced a whole service and there are no provisions for a worker to personally provide services to the company outsourcing the arrangements, then that company will not have any obligations under these new rules. In this situation, the company taking on the outsourcing contract may itself be the end user for the purposes of this legislation. It will be important to ensure that appropriate dialogue is entered into where such arrangements exist, so that early agreement can be reached as to who has the end user responsibilities under the new legislation.
Now, at the heart of these new off-payroll working rules is the requirement for the end user of the worker services to make a well-informed status determination. To do this, the end user must consider a hypothetical contract directly between them and the worker, which effectively ignores the worker's personal service company. They must establish the terms and conditions, underlying working arrangements, and the other relevant facts for that hypothetical contract, and consider these in light of the status indicators which are relevant to determining whether a contract is one of employment or self-employment. Where the hypothetical contract is one of employment, the fee payer, on receiving the status determination from the end user, must account for the tax and NIC due under PAYE when paying the worker's personal service company. Now, these status indicators have evolved over time from case law and are not set out in legislation at present. However, the way that status is determined is subject to a separate review, and it may be that we see these status indicators change in the future or become legislated for. It is frustrating, of course, that this could not have been completed before the new off-payroll working rules are introduced on the 6th of April 2020. However, currently there are more than 10 status indicators to consider, but the importance of each and how much weight each carries in isolation when determining status varies. Arguably, the most important ones are right of substitution, mutuality of obligation, control or right of control, and financial risk. It is necessary to consider engagements on a case-by-case basis, consider the overall picture which emerges on each engagement, and then make a decision about status based on the overall picture which emerges for each engagement. The end user must take reasonable care to consider status and pass the status determination and the reasons for it to the worker and the party they contract with. If an end user does not apply reasonable care, they can be held responsible for the tax, NIC, and apprenticeship levy due. Now, these status determinations must of course be carried out at the outset of each engagement, but for longer term engagements there is a need for ongoing review when something changes and or at regular intervals. HMRC's Check Employment Status for Tax, or CESS tool, can be used for making these status determinations. Indeed, many end users in the public sector are already using this tool to make their status determinations under the off-payroll working rules there. The CESS tool has, however, come in for a lot of criticism recently. Many take the view that it is not fit for purpose in its current format and that it does not make accurate status determinations. This seems to have been confirmed in a number of often high-profile IR35 cases which HMRC have recently lost at tribunal. A particular criticism is the CESS tool's failure to properly consider mutuality of obligation. Based on HMRC's assumption that mutuality of obligation is already present in all contractual arrangements, regardless of whether they are one of employment or self-employment. This particular point has proved to be ill-judged, as recent tribunal cases have taken a different view and highlighted how important mutuality of obligation can be when determining status accurately. Now, while the CESS tool does have a role to play in helping end users make well-informed status decisions, it is clearly not working as it should be at present and needs to be improved. While HMRC stand by the tool and claim that it gives a clear answer in 85% of cases, they are still committed to improving it. They are, therefore, going to enhance the CESS tool and the associated HMRC guidance by the 6th of April 2020. The improved CESS tool and guidance should be available for use later this year.
The government has confirmed that from 6th of April 2020, legislation will apply that will set out minimum requirements for a client-led status disagreement process in relation to determinations under the new rules. The government has said that in their view, the end user of the workers' services is best placed to understand the working practices and the contractual terms and to respond to any disagreements in real time. Under the draft legislation, the worker or the fee payer will be able to make representations to the end user who made the original determination if they believe that the original conclusions were incorrect. The end user will then be obliged to consider the representations and to respond within 45 days of receipt, advising either that they believe that the original conclusion was correct, or if not, they will be required to issue a new status determination. It will be important for end users to ensure that they do in fact respond within 45 days, as failure to do so will result in the end user being deemed to have the fee payer responsibilities.
Now, moving away solely from the obligation of end users, this slide clearly shows the main obligations of each party in a labour supply chain under the new off-payroll working rules. The end user, shown as the client on the slide, is required to make their status determination and pass this and the reasons for reaching it to the worker and the party they contract with, which in this case is an agency. Agency 1 on the slide. That agency is then required to pass the status determination and the reasons for making it down the chain until it reaches the fee payer, who must then apply the appropriate treatment when paying the worker's personal service company. If the determination states that the worker is deemed to be an employee, the fee payer must account for the tax, employees and employers NIC, and where appropriate the apprenticeship levy due under PAYE, and pay the worker's personal service company after deducting that tax and NIC. The liability for the tax and NIC due, where a worker is deemed to be an employee, moves down the labour supply chain and sits with each party in the chain until such time as they satisfy their obligations. If a party does not satisfy its obligations, then it will be held responsible for the liability. For example, if the agency which contracts with the fee payer does not pass the IR35 determination to the fee payer, it will be held responsible for any tax and NIC due under PAYE. Each party in the chain must therefore have an appropriate process in place to meet their obligations. This will be of more relevance to longer labour supply chains and will be of particular interest to recruitment businesses and agencies which sit between the end user client and the worker's PSC in the labour supply chain. Now, the draft legislation and the government's response to the off-payroll working policy paper and consultation confirms that the controversial transfer of liability provisions will form part of the new rules from the 6th of April 2020. As highlighted on the previous slide, the liability for the tax, NIC and apprenticeship levy due under PAYE, where a worker is deemed to be an employee, passes down the labour supply chain as each party satisfies its obligations under the new rules. The transfer of liability provisions, however, will potentially allow HMRC to transfer those liabilities to an agency at the top of the labour supply chain, i.e. the first agency, which has the direct contract with the end user client, or to the end user themselves, where there is non-compliance further down the labour supply chain, and it is not possible for HMRC to collect the amounts due from that offending party. HMRC have stated that these transfer of liability provisions will only be applied in certain circumstances, for example where tax avoidance is involved, rather than where there is a genuine business failure. HMRC guidance setting out the circumstances in which HMRC will not seek to apply these liability transfer rules will be issued in due course, and HMRC will also outline the steps which organisations can take to ensure due diligence on their internal processes. So it looks like we will not know exactly how the transfer of liability provisions will work in practice until such time as this HMRC guidance is issued. Now this slide illustrates how these transfer of liability provisions could work. In this example, the client undertakes the status determination and passes this determination and the reasons for reaching it down the chain to the party they contract with, being Agency 1. They also pass the determination to the worker, although this step is not highlighted on the slide for the sake of simplicity. Let's assume that the status determination deems the worker to be an employee. Agency 1 passes the determination and the reasons for reaching it to Agency 2, and Agency 2 passes this down to Agency 3. The process breaks down, however, when it reaches Agency 3, who failed to pass the determination and the reasons for reaching it to the fee payer. The offending party is therefore Agency 3, but if HMRC cannot collect the PAYE liabilities due from Agency 3, in certain circumstances, which have not yet been confirmed, HMRC will be able to transfer the liability to Agency 1. If HMRC cannot collect the PAYE liabilities from Agency 1, they will then be able to transfer the liabilities to the end client. While we don't know exactly how this will work at this stage, what is clear is that end clients using the services of workers via their own intermediaries and agencies at the top of the labour supply chain will need to be particularly mindful of these rules where such workers are sourced through longer labour supply chains. The end client and the first agency will need to understand the labour supply chain and ensure that parties further down the chain are aware of and do meet their obligations under the rules. Measures may also need to be taken by the end client and the first agency to protect themselves from unexpected liabilities. For example, by introducing indemnities into contractual arrangements and seeking appropriate insurance cover.
As we've demonstrated throughout this presentation, the proposed new rules will place significant obligations on medium and large businesses who use the services of workers operating through intermediaries such as personal service companies. Public sector entities will also need to review and update their processes and procedures to be compliant with the additional obligations from 6th of April 2020. As a starting point, we would suggest that private sector businesses using the services of off-payroll workers should identify whether or not they are an exempt small business, taking into account the complexity involved where they are a new business or part of a group. It would then be important to identify all existing arrangements with off-payroll workers, including those sourced via an agency, and assess whether or not those arrangements will be within the new rules, and if so, work out the potential cost impact. Consideration will need to be given by the end user as to who in the business will be responsible for making status determinations and for dealing with status disagreements and ensuring that all time limits are met. Payroll and account systems will also need to be reviewed, updated and tested as necessary to ensure that obligations for identifying appropriate invoices and accounting for PAY and NIC are met. Finally, it's important to ensure that you provide appropriate communication to both off-payroll workers and your own staff around your approach to the new rules as soon as possible. Within RSM, we have a team of specialists with significant experience of helping clients prepare for the new rules from 6th of April 2020. We're also able to call upon the expertise of the employment law solicitor specialists within RSM Legal LLP. We're currently working with many clients to help them with all aspects of their preparations, including facilitated workshops for all stakeholders within the business to help raise awareness of the changes and to also help prepare a project implementation plan. Assistance with the status determination and status disagreement process, the preparation of appropriate communication material, and assistance with ad hoc queries on all aspects of the new rules. Further details on how we can help and our latest insights can be accessed at www.rsmuk.com/IR35. Alternatively, please speak to one of our specialists shown on the following slide or speak to your usual RSM contact. That concludes today's presentation, and we hope that you have found it useful.